Hi friends, I am B.S. Bhaskara Dev, High Court Advocate, enrolled in 1979. I would like to share some subject under the caption sharing of legal knowledge. The question in dispute is, one of my friends questioned whether in a simple suit for injunction, the title of the plaintiff can be gone into by the courts, or only position has to be seen and given the judgment. In my humble submission is, it depends upon, there is no hard and fast rule that the title of the plaintiff should be gone into. Hard and fast rule is not there, but it depends upon the situation and circumstances of the case and upon the document upon which he comes before the court for injunction. Either he should be a owner, first he should be a owner, and he should have possession over the suitable property. That is a must. Though if he comes with a genuine document, it's okay, no problem. If he comes with a based upon only a gift settlement deed, a registered gift settlement deed without any linked documents, it's a fabricated document, concocted document. If the defendant disputes the title of the plaintiff on the basis of the gift settlement deed, if he disputes the genuineness of the gift settlement deed, in such a case it becomes necessary for the party, for the plaintiff, to come with an amendment petition, and he has to amend it as a suit for declaration, for suit for perpetual injunction or declaration. Without doing it, that too within the period of limitation. The period of limitation is 3 years from the date of knowledge. When the defendant has raised this dispute in the written statement, that is to be taken into consideration. That is a knowledge of the knowledge of the plaintiff from the date of knowledge within 3 years. So if he doesn't follow this and if he doesn't do it, and the suit naturally gets dismissed if he fails to prove his title and position, then he will go to first appeal. It will be dismissed. Second appeal also dismissed on the ground that he has failed to prove his title and position of the suit scheduled property. That is the law. And in such a situation, if he comes back and files a suit for declaration before the lower court without honoring the judgments of the fact-finding courts and also the high court, then naturally this person is not the suit for declaration filed before the lower court is not maintainable. It is not maintained. It has to be thrown out at the threshold. After the high court has given a judgment, second appeal on substantial cause, saying that there is no substantial question of law raised by the plaintiff, then naturally he cannot maintain any suit at the lower court level, because a substantial question of law is not raised, and he has no right to file the suit as a fourth round litigation. So this type of suits should not be encouraged by the lower courts, and they should be thrown out at the time of registration of the plaintiff itself, registration of the suit. That's my humble submission. Courts are to be respected. The judgments of all the three courts are to be respected, and the plaintiff should not be given any opportunity to come and re-agitate and relitigate the same thing, which may ultimately lead to several litigations like CRPs, first appeal, again second appeal from the relitigated case. These things should not be encouraged. That is my humble submission. Law should be strictly followed, and genuine parties should get justice without any delay. Justice delayed is justice denied. And ignorance of law is no excuse. These things you have to be kept in mind, and the judgments of the higher courts should be always respected by all the people. That is the law. Law should be followed strictly. That's my humble submission.